Okay, I could resist the temptation no longer and decided that I want to talk about the Coca Cola 2020 case. Here you can see an interesting historic collection of Coca Cola bottles. And if you want more details of the case, here is the case number. It's a United States Tax Court decision from 18 November 2020. Now, as you can see, this is quite a lengthy decision, and we will try to move through it as quickly as possible to keep the video a reasonable time. So let us start with a very high-level look of the structure. You had the Coca Cola Company at the top, which is a US parent, obviously, and then underneath you had another US company called Export, who basically dealt with all the non-US sales. And Export had a branch in Mexico. It had subsidiaries in Brazil and Chile, which it owned directly. And then it had a CFC, Atlantic Industries in the Cayman Islands, which held subsidiaries in Costa Rica, Egypt, Ireland, and SZ stands for Eswatini, or Swaziland as we knew it before. And these companies were making Coca-Cola syrup, basically, or syrup for various beverages, including Fanta, etc., but they were making syrup, basically. And then there were other service companies, and then what happened was you had independent bottlers. Most of them were independent, and while there were only 6 or 7 supply points which made the syrup, the bottlers were numerous and were selling the Coca-Cola beverages and other beverages to local supermarkets and restaurants and all that. And they acquired the concentrate or the syrup from the supply points, right? And then they would sell them to whoever wanted to buy them. And the service co's did local marketing. They were regional service co's, and they did local marketing with the bottlers and made sure that the Coca-Cola products and brand and everything gets pushed as much as possible. Now, the gist of this case, before we go into further detail, is that the adjustment was for the supply points. The IRS said that they earned simply way too much. And Coca-Cola's defense was that, yes, but if you look at what the service co's did together with the supply points, then the supply points actually had very, very valuable marketing intangibles. And they got to that point because the service co's charged the supply points for some of the marketing expenses which they paid on behalf of the bottlers. Not all of it, and in a very haphazard manner. But that was the gist of the argument, and well, it doesn't work like that in the transfer pricing world. You cannot merge legal entities, especially not from different countries, and then claim that that is the arm's length consideration that they are receiving. So let's go into further detail about each company's role and the arguments of the court. But before we do that, okay, so let me just explain the case a little further. The gist of respondent's position, respondent in this case is the IRS, is that the supply points paid insufficient compensation to petitioner, which is Coca-Cola, for the rights to use Coca-Cola's intangible property. The Irish and Brazilian supply points account for roughly 85% of the disputed income adjustments. And somewhere else in the case, they say that, you know, Ireland had an effective tax rate of, I think, 1.4%. So no wonder they wanted to move income, right? For 2007 to 2009, Coca-Cola reported income from its foreign supply points using the 10-50-50 method, as it had done in the 11 previous years. This was a formally apportionment method to which the petitioner and the IRS have agreed in a closing agreement executed in 1996, which covered the years 1987 to 1995. This method permitted the supply points to retain profit equal to 10% of their gross sales, with the remaining profit being split 50-50 with Coca-Cola. So because the closing agreement specified the compensation due to Coca-Cola for use of its intangible property, the amounts due to Coca-Cola under the 10-50-50 method were in the nature of royalties. However, the closing agreement back in the 90s permitted the foreign supply points to satisfy their royalty obligations by paying actual royalties or by repatriating funds in the form of dividends. Upon examination of the 2007 to 2009 returns, the IRS concluded that a 10-50-50 method did not reflect the arm's length because it overcompensated the supply points. And it's important to realize that, you know, even though this was a method for settling the old years back in the 90s, they never said that this method can be used going forward. I think in Europe, for instance, there would have been legitimate expectation that if you've closed an assessment, then you can go forward on that same basis, because one would presume that the assessment that is at arm's length. But this was not the case here in front of the U.S. tax court. The IRS reallocated income to Coca-Cola using a comparable profits method, or I guess what we would call a TNMM, treating independent Coca-Cola bottlers as comparable parties. In other words, the Green Party. To implement its bottler CPM, the IRS determined the average return on operating assets for a group of independent Coca-Cola bottlers. So they said, okay, if we look at the bottlers, they do more or less the same as the supply points do. Let's look at what the bottlers' average return on assets were, and in this way, these were gross profit margins. And then we apply those same profit margins to the supply points. The methodology produced substantial reallocations from the Irish and Brazilian supply points and somewhat smaller ones from the others. The petitioner contends that the independent Coca-Cola bottlers are not comparable to supply points because the latter, in other words, the supply points, own immensely valuable intangible assets. These assets, which the petitioner or Coca-Cola calls marketing intangibles or IP associated with trademarks, allegedly were created when the supply points financed consumer advertising in foreign markets. Coca-Cola urges that the bottlers, by comparison, are marketing light businesses that operate at a different level of the market. Now, if we look at the service codes, during 2007 to 2009, the company appears to have had at least 60 foreign service codes, each serving one or more international markets. The service codes were responsible for local advertising and in-country consumer marketing, which they carried out with assistance from third-party media companies and creative design firms. The service codes were also responsible for liaison with the local bottlers, a function petitioner called franchise leadership, as we see on the card. A few service codes had research and development centers. The supply points had little or no direct ownership interest in the service codes that served these national markets. Most of the service codes were owned by export. If we look at the bottlers, the vast bulk of the Coca-Cola beverages were produced and distributed by the bottlers. During 2007 to 2009, the company had about 300 independent bottlers. The bottlers produced numerous non-alcoholic ready-to-drink beverages generally, but not exclusively, under the petitioner's brands. The bottlers produced most of these beverages using concentrate manufactured by the supply points. As appropriate to a particular drink, the bottlers mixed the concentrate with purified water, carbon dioxide or sweeteners and or flavoring, injected the finished beverage into bottles and cans, packaged and warehoused these items pending distribution, and delivered beverages to retail establishments that included supermarkets, small stores, bars and restaurants. Although independent bottlers were crucial for the Coca-Cola system, Coca-Cola occasionally acquired bottles and brought them temporarily in-house. This occurred when a bottler encountered financial difficulty or had to be divested in a merger. In 2006, the Coca-Cola Company grouped these control bottles into a single management unit called the Bottler Hospital, which I think is rather sweet, and supervised their activities directly from Atlanta. Generally, petitioners or Coca-Cola's objective was to divest the ownership of these control bottlers as soon as they had recovered their footing operationally and financially. Now, if we look at the supply points, they manufactured concentrate, right, or the syrup. Their manufacturing activity consisted of procuring raw materials and using the Coca Cola Company's guidelines and production technology to mix and convert raw materials into concentrate. Their procurement activities were limited. After completing the manufacturing process, the supply points packaged the concentrate into kits tailored to the needs and capacities of the bottlers to whom they distributed. All of the steps were governed by a detailed manufacturing protocol dictated by Coca-Cola. The Coca-Cola's expert agreed that this manufacturing activity was a routine activity that could be benchmarked against the activities of contract manufacturers. In addition, the vast majority of the people who worked at the supply points were engaged solely in concentrate production. In 2009, the Irish supply point had 599 employees, of whom 588 were engaged in concentrate production. The Costa Rican company had 60 employees, all of whom were engaged in concentrate production. The Swazi supply point had 153 employees, 135 of whom were engaged in concentrate production, and then the Brazilian, Chilean, and Egyptian supply points performed other business activities, including marketing, sales, and finance. And you got to remember, we'll see that later, but the Egyptian supply point was completely loss-making. To the extent the supply point employees engaged in such non-production activities, so for these three entities, they generally performed functions similar to those performed by Servco employees and overseen by BU leadership. And the Servco employees, or the Servcos, were benchmarked to be compensated on a cost plus. I think it was between 6 and 10%. Now, if we look at supply chain, the Coca-Cola leadership often shifted production to supply points located in jurisdictions that offered tax or tariff incentives. The Irish supply point, which operated an income tax rate of 1.4%, as I mentioned before, during the period issue, built a state-of-the-art plant in 1999. The company shifted to the Irish supply point from the Mexican supply point, or roughly 50% of the latter's production of concentrate for Coca-Cola rate, without really compensating Mexico. And it didn't have to, because the contracts between the Mexican supply point and Coca-Cola Company or export did not say that any compensation is due. As a matter of fact, those contracts could be terminated with very short notice periods. Okay, so the Coca-Cola Company directed numerous shifts of production to the Irish supply point between 1984 and the tax years in issue. During 2007 to 2009, the Irish supply point had by far the largest production of any foreign concentrate plant, supplying bottlers in more than 90 national markets. And then in 2008, the Coca-Cola leadership started setting up a similar plant in Singapore with similar kind of tax incentives to move a lot of the supply point work to Singapore, again to obtain tax advantages. From here, the court goes on to describe the contractual arrangements between the different parties. I'm going to skip that for now because it gets back to that when it comes into its argumentation. What I'd like us to do is look at some of the numbers so we can understand from a numerical perspective what was going on in this case. Let's do that in the next video.